I've been on the road a little over 5 years, but I've been in prison 9 years.
Do you have feelings of regret?
Definitely.
Or remorse for all the things
Definitely.
you did that all added up to whether it was that crime
Definitely.
or not?
Regret, shame, remorse, of course. I've committed armed robberies, I've committed burglaries. I'm by no means some angel poor innocent picked up out of society. My life took me here. And prison ain't cool. I've been coming to prison. This is my 7th time coming to prison.
Kerry Lynn Dalton was convicted and sentenced to death for the 1988 torture and murder of Irene Melanie May in San Diego County, California, because she thought May had stolen her jewelry. She was sentenced to death on May 23, 1995. I'd heard that. She had an interesting, sad story, one she was eager to tell because she was still angry. Jillian Hansard answered the door of her Colleran Township apartment with an adorable newborn baby tucked in the crook of one arm. Sarah, she says, was born on March 22nd. Jillian rubs her finger absently through the infant's abundant dark hair. The baby looks like her mother, she says. Mothers and daughters. That's what Jillian wants to talk about. A year ago, in a business law class at Colleran High School, Jillian was watching a taped TV show about women on California's death row. As Joan London interviewed Kerry Lynn Dalton, Jillian realized she was listening to the woman who murdered her mother. It made me feel kind of sick, she says. It is a perfectly understandable reaction. Before she died in 1988, Irene Louise May was beaten, stabbed, injected with battery acid, and tortured with electric shocks. Jillian knew these things, having read news accounts, but she had never seen the woman convicted of the murder. Then I had to listen to her talk about how tough it was for her to be in prison, Jillian says. She said her children don't come to see her. At least that's their choice. I have no choice. She took that away from me. She says it made her angry that the woman had a national audience for her complaints. They never asked me how I felt. Bad. Memories. Jillian was only 5 when her mother was killed. Her memories are not good. Addicted to drugs, Irene May often left Jillian and her 2 younger brothers to fend for themselves. We'd be in the bedroom, kinda hiding, and I'd try to take care of them, she says. It's hard, she says, to separate what I remember from what I've been told over and over. She believes she sometimes begged for food, but she knows she did her best to care for her little brothers. My mother loved us, she says. She was trying to stay clean. She has seen records from San Diego Social Services. The children had been removed from their home, but their mother was trying to get them back. She never got the chance to be a better person. Jillian was adopted 2 weeks before her 7th birthday. They wouldn't let me be adopted with my brothers, she says, because all I wanted to do was to take care of them. I thought that was my job. At age 5. Now, here comes the good part. Her adoptive parents are Steve and Cinda Gorman, co-pastors of Westwood First Presbyterian Church. I came with a lot of baggage, Jillian says, but I'm proud of who I became, and I love the family I have now. This includes her husband, Charlie, a mechanic. Sarah fusses a little as we talk, and Jillian soothes her competently and kindly. She is a good mom, child neglect, drugs, murder. A tiny girl hiding with her brothers thinking they were her responsibility. Then taking on real responsibility as an adult. Proud of who she became. Writing her ending to the story. I must admit, up front, I'm on death row. I'm sure that's going to scare off a few folks. Perhaps if you continue to read this, I can capture just a bit of your interest. First though, my crime? I've been convicted of a murder without not only a body, but also without any weapons or a crime scene. Now that I've said that, I will add this is pretty foreign to me, running an ad, fronting myself off, that my burden is being lonely. I've lived an extreme, free, and of course wild life, which naturally landed me here. Now, I've grown in a much different style. I have strength, but I've also learned a great deal of respect for all things and all people. I never take what isn't mine and live honestly and truthfully. I am still searching for myself, though I'm not looking for anybody to make my path. I want to smile and laugh and have fun. I'm intelligent and decent, and I have serious conversations as well. Physically, I'm in perfect shape. I'm tall, 5'8", yet small, only 126 lbs. Every night I exercise and secretly dance. I love music. It's my great escape. When I was free, my greatest addiction was being a thrill seeker. And although this holds no danger for me, it's still a risk. I'll end with something Axl Rose saying, "I'm still all right to smile." 3 people were arrested in a torture murder case in which nobody was found after they admitted, and in several instances bragged about, their roles in the crime. It was revealed in court Tuesday. A preliminary hearing is being held to determine if the 3 should stand trial on murder charges for killing Irene, Melanie May, in June 1988. In addition to attacking her with a knife, a screwdriver, and a frying pan, they allegedly injected the victim with battery acid. Richard L. Cooksey, a district attorney investigator with the Metropolitan Homicide Task Force, testified Tuesday that Mark Lee Tompkins, 29, Kerry Lynn Dalton, 39, and Cheryl Ann Baker, 28, implicated themselves in the murder in a mobile home in the isolated East County community of Live Oak Springs. According to one of his acquaintances, Tompkins explained how the 3 planned to give May a fatal injection in retribution for stealing some items belonging to Dalton. Cooksey testified. Tompkins said the victim was given electrical shocks and then a skillet was used to smash her knees, according to the statement given by Donald McNeely. The body was cut up and the parts were buried on 2 Indian reservations. To make it hard for police to obtain search warrants, Cooksey quoted McNeely as saying, "Dalton and Baker also allegedly admitted to other people their role in the killing, according to the evidence." After the preliminary hearing, Municipal Judge Lawrence Sterling is expected to decide whether the 3 should stand trial in Superior Court. In this mandate proceeding, Kerry Lynn Dalton, under a judgment of death, seeks to compel the San Diego County Superior Court to grant various post-conviction discovery requests in connection with her petition for writ of habeas corpus, pending before the Supreme Court. Penal Code 1 Section 1054.9 allows persons sentenced to death or life in prison without the possibility of parole to file a motion for post-conviction discovery to assist in seeking a writ of habeas corpus. Kerber 1054.9, sub D. A. After a trial court has ruled on a Section 1054.9 discovery motion, either party may challenge that ruling by a petition for writ of mandate in the Court of Appeal. In Resteele 2004, 32 Cal 4th 682, 692 Steele. Dalton challenges the denial of 50 post-conviction discovery requests, including 26 requests that she claims were denied in part, or effectively limited, because the prosecution was required to disclose only material in the possession of the prosecution team. Dalton contends that the court below erred by 1, defining the prosecution team too narrowly, and refusing to order disclosure of all materials in the pretrial discovery order made by the judge who presided at the trial. On June 26, 1988, Dalton's ex-roommate Irene Melanie May was murdered at the Live Oak Springs trailer park. At the time, May was tied to a chair in Joanne Fedor's trailer. Fedor was not present. Dalton injected battery acid into May with a syringe. Co-defendant Cheryl Baker hit May with a cast-iron frying pan. Baker and another co-defendant, Mark Tompkins, then stabbed May to death. Later, Tompkins and a 4th individual, who was only identified as George, disposed of May's body, which was never found. On November 13, 1992, the San Diego District Attorney filed an information charging Dalton, Tompkins, and Baker with conspiracy to commit murder. In July 1993, the trials of the 3 co-defendants were severed. In July 1994, Baker pled guilty to second-degree murder, and Tompkins pled guilty to first-degree murder. Baker was a prosecution witness at Dalton's trial, which began in early 1995. Tompkins did not testify, but the prosecution presented statements by him through the testimony of one of his cellmates. On February 24, 1995, the jury found Dalton guilty of conspiracy to commit murder and murder. The jury also found the 2 special circumstance allegations to be true. Following the penalty phase, the jury returned a verdict of death. On May 23, 1995, the trial court sentenced Dalton to death because it is presumed to know about all information gathered in the government's investigation. The prosecution is responsible for the materials possessed by other agencies acting on the government's behalf that were collected in connection with the investigation and the information in its files. As noted by the Steele Court, the scope of the disclosure duty under Section 1054(9) is consistent with the prosecution's constitutional duty under Brady, supra, to disclose exculpatory information. The scope of this disclosure obligation extends beyond the contents of the prosecutor's case file and encompasses the duty to ascertain as well as divulge any favorable evidence known to the others acting on the government's behalf. As a concomitant of this duty, any favorable evidence known to the others acting on the government's behalf is imputed to the prosecution. The individual prosecutor is presumed to know all information gathered in connection with the government's investigation. Thus, the prosecution is responsible not only for evidence in its files, but also for information possessed by others acting on the government's behalf that was gathered in connection with the investigation. However, the prosecution cannot reasonably be held responsible for evidence in the possession of all governmental agencies, including those not involved in the investigation or prosecution of the case. Conversely, a prosecutor is not obligated to disclose exculpatory evidence or information to a defendant unless the prosecution team actually or constructively possesses that evidence or information. Thus, information possessed by an agency that has no connection to the investigation or prosecution of the criminal charge against the defendant is not possessed by the prosecution team, and the prosecutor does not have the duty to search for or to disclose such material. The important determinant is whether the person or agency has been acting on the government's behalf or assisting the government's case. Dalton claims the La Mesa Police Department was a prosecution team member because it assisted investigators in this case by directing them to Jeanette Bench, who testified for the prosecution at trial about statements made by suspects and others connected to the case. Bench spoke to a La Mesa police officer about May's murder, and the officer contacted District Attorney Investigator Richard Cooksey, who interviewed Bench. During the Cooksey-Bench interview, Bench related that detectives of the La Mesa Police Force had interviewed her. Bench also said that she and Lacey Grote had heard Fedor flipping out and saying that Dalton and Tompkins killed that girl at Fedor's house. Bench told Cooksey, "Some of the La Mesa detectives did go and talk to Lacey after I talked to the people in La Mesa. Contrary to the motion court's ruling, the record shows that the La Mesa Police Department assisted the prosecution and should be deemed part of the prosecution team. The prosecution learned of Bench's existence because of the La Mesa Police Department." Dalton also alleged that the La Mesa Police Department had provided reports to the trial. On remand, the motion court shall allow Dalton to make the requisite showing under Barnett Supra 50 Cal 4th at page 894 that a La Mesa Police Department report about an interview with Bench exists. If Dalton can adequately show the report exists, the prosecution shall be ordered to turn it over to her. Similarly, Dalton's claim that the El Cajon Police Department was part of the prosecution team has merit. El Cajon police officer Richard Neiseth contacted Sheriff Investigator Terry Wisniewski after discussing May's murder with Chris Dalton, the former brother-in-law of Dalton. Wisniewski then interviewed Chris Dalton, who also provided information about Dalton. The prosecution at one point intended to present this information during the penalty phase. An El Cajon police sergeant also informed Wisniewski that Kathy Eckstein's son knew where a body was located. Wisniewski followed up by interviewing Eckstein, who testified at Dalton's trial on behalf of the prosecution. We conclude that by providing information on the government's case, the El Cajon Police Department was part of the prosecution team. On remand, the motion court shall allow Dalton to make the requisite showing under Barnett, Supra, 50 Cal 4th at page 894, that an El Cajon Police Department report concerning Chris Dalton's interview exists. If Dalton shows adequately, the motion court shall order the prosecution to turn the report to Dalton. We also find the motion court correctly excluded the Detention Services Division of the Sheriff's Department and the CDCR except to the extent that they were directly involved in interviewing witnesses or developing evidence in this case. This court's opinion in Barrett, Supra, 80. In Barrett, the defendant was charged with murdering his cellmate in a state prison and sought discovery of various records maintained by the California Department of Corrections, which was the forerunner of CDCR. We held the prosecution had no duty to produce most of the documents sought because the department had maintained them in its administrative function of running the prison. Further, the defendant was entitled to materials prepared in the department's investigation of the murder, so long as they fell within the scope of Section 1054.1, subdivisions A through F, but not to materials maintained by the department in its administration of the prison. In a related argument, Dalton contends the motion court erroneously limited 26 of her post-conviction discovery requests by requiring the prosecution to turn over material only if it was in the possession of the prosecution team. This contention is without merit. There was no error. Materials are subject to disclosure only if they are currently in the possession of the prosecution and law enforcement authorities that were involved in the case. Does not impose a duty to preserve materials or to search for or obtain materials not currently possessed by the prosecution team. In its statement of decision, the motion court wrote, "The trial judge made discovery orders that were far broader than required by the discovery statutes and the Constitution, and exceeded his authority." Accordingly, the motion court rejected several of Dalton's requests for post-conviction discovery of materials that she claims were ordered by the trial court and therefore required to be produced under Steele. In Steele, the Supreme Court pointed out that Section 1054.9 is broader than a file reconstruction statute and allows discovery of material to which trial counsel was legally entitled. Does not limit post-conviction discovery to materials the defendant possessed to the exclusion of materials the defense should have possessed. If the legislature had intended to limit the discovery to file reconstruction, it could easily have said so. In setting forth what post-conviction discovery a capital defendant is entitled to under Section 1054.1, beyond file reconstruction, the Steele court listed materials the prosecution should have provided at time of trial because they came within the scope of a discovery order the trial court issued at that time, a statutory duty to provide discovery, or the constitutional duty to disclose exculpatory evidence. Using the disjunctive "or," the Supreme Court intended to designate three alternative categories of available post-conviction discovery materials. We believe the court's selection of the disjunctive "or" was an informed and thoughtful choice and intended it to be accorded its ordinary meaning. Namely, three discrete bases for obtaining post-conviction discovery under Section 1054. Nonetheless, the motion court chose to disregard this language because 1. It inferred the Steele court was considering only trial court discovery orders that were lawful, and 2. In any event, the language was dictum since the case before the High Court did not involve a trial court's discovery order. We find neither of these explanations justifies the court's decision to discount the Steele language. Significantly, the Steele court could have but did not modify a trial court's discovery order by using proper, consistent with the law, or any other synonymous adjective. Had the Supreme Court intended to indicate it was discussing only proper legal discovery orders, it would have done so. Just as we would not add language to a statute, we cannot condone adding language to the Steele court's construction of a statute. Our state's highest court can include limiting language when it sees fit. Furthermore, we disagree that the Steele language, part of the Supreme Court's construction of Section 1054.9, is strictly dictum. At the beginning of its opinion, the Steele court clarified that it issued an order to show cause to resolve important procedural and substantive issues regarding. When the Supreme Court interprets a newly enacted statute, it must make do with those vehicles which fortuitously present themselves to accomplish the task. Under these circumstances, discounting statutory construction language as dictum, because the language was not essential to the underlying decision, is, in our view, short-sighted, akin to failing to see the forest for the trees. Assuming arguendo that the discovery order issued by the trial court language of Steele is dictum, it is our Supreme Court's dictum and commands serious respect by the inferior courts of this state. Santa Monica Hospital Medical Center, Fine Superior Court. When the Supreme Court has conducted a thorough analysis of the issues and such analysis reflects compelling logic, its dictum should be followed. Even if properly characterized as dictum, statements of the Supreme Court should be considered persuasive. United Steelworkers of America versus Board of Education. Put another way, all courts of this state should generally follow dicta from the California Supreme Court. See also Auto Equity Sales, Inc. v. Superior Court. Under the doctrine of stare decisis, all tribunals exercising inferior jurisdiction are required to follow decisions of courts exercising superior jurisdiction. Otherwise, the doctrine of stare decisis makes no sense. The decisions of this court are binding upon and must be followed by all the state courts of California. The language discovery order issued by the trial court used by the Steel Court was not inadvertent, ill-considered, or a matter lightly to be disregarded. The motion court erred when it effectively ignored the Steel language. The motion court also overstepped its bounds by improperly finding the trial court's discovery order. Generally, the law permits a trial court to correct its prejudgment errors. This general rule, however, is not applicable when a different judge is reconsidering a ruling. For one superior court judge, no matter how well intended, even if correct as a matter of law, to nullify a duly made erroneous ruling of another superior court judge places the second judge in the role of a one-judge appellate court. The Idaho Superior Court of Los Angeles County, though comprised of some judges, is a single court, and one member of that court cannot sit in review on the actions of another member of that same court. Citation. Stated slightly differently because a superior court is, still, one tribunal. An order made in one department during the progress of a cause can neither be ignored nor overlooked in another department. That was what happened here, and it constituted an error. Furthermore, whether the trial court's discovery order was proper is a peripheral issue in the context of post-conviction discovery and under the circumstances of this case. In enacting Section 1054(9), the legislature wanted to allow capital defendants to efficiently reconstruct their defense attorney's trial files that were lost or destroyed after trial. Here the record shows that by the time of the hearing on the original discovery motion, none of the parties disputed the prosecution had complied with 11 of 18 categories of evidence requests. The trial court ordered the continuing discovery of these 11 categories without objection or any other challenge from the prosecutor. Among the categories of evidence requests to which the prosecution had complied was the request to produce all statements regarding this case, whether written or oral, made by potential witnesses in this case, regardless of whether the prosecution intends to call them at the time of trial, which is at issue in this proceeding. Thus, this category of requests was part of the discovery order. Significantly, the prosecution's compliance took place before the cases of Dalton, Baker, and Tompkins had been severed, and, therefore, we can assume trial counsel had received the pertinent witness statements relating to a joint trial of Dalton, Baker, and Tompkins. If that is the case, then the motion court's ruling rejecting parts of the trial court's discovery order would have defeated the primary purpose of Section 1054.9, namely, reconstruction of counsel's trial file. Dalton contends the motion court erroneously denied 11 post-conviction discovery requests because the original discovery order was improper. We consider them seriatim. The motion court denied the request for statements Judy Moran, who was on the prosecution's witness list for co-defendant Baker's trial, made to Baker's defense team to the extent the statements were shared with the prosecution. Dalton claimed that Baker told Moran that Tompkins killed May and made Baker watch, which contradicted Baker's testimony against Dalton and Tompkins' version of the events as testified to by a hearsay declarant. If Baker's defense team shared Moran's statements with the prosecution team, the statements would be discoverable because they were within the scope of the trial court's discovery order. The motion court orders the prosecution to produce the statements if they are in the possession of the prosecution team. The motion court denied the request for statements of Roger Tavolazzi, who was not on the prosecution's witness lists. Dalton claimed Tavolazzi was a close associate of Dalton, and a district attorney investigator had expressed an interest in interviewing Tavolazzi. Additionally, Dalton contended that Moran told the investigator that Tompkins had discussed the murder with Tavolazzi. This was an insufficient basis for ordering the production of statements by a non-witness who did not appear on any prosecution witness lists. The motion court correctly denied Dalton's request. Concerning Dalton's request for a statement by an unknown, confidential informant, white female jail inmate made to a sheriff's deputy, the motion court granted the request to the extent that the prosecution team has no documentation beyond a report prepared by the deputy years after the fact. Dalton has the deputy's belated report. This ruling was correct. Dalton sought post-conviction discovery of all rough or handwritten notes of interviews of potential or actual witnesses, defendants, or suspects by any law enforcement representative involved in the case. The motion court ruled, to the extent the witnesses were on the DA's witness list for Dalton's trial or testified at trial, the DA must provide all reports, including handwritten notes of the witnesses' statements that are in the possession of the prosecution team. We agree with Dalton that the motion court should have included potential witnesses on the prosecution's witness list for Baker's and Tompkins's trials under Steele. As to notes of law enforcement interviews of suspects, Dalton would be entitled to any that are in the possession of the prosecution team under Brady. On remand, the motion court shall order the prosecution to turn over handwritten notes of those statements possessed by the prosecution team. Concerning Dalton's request for witness statements provided by other defense counsel, the motion court ruled, for any witnesses who were on the DA's witness list or who testified, any reports of statements still in the possession of the prosecution team must be provided. This is whether the statements were taken directly by the prosecution team or taken by other investigators and then provided to the prosecution team. This ruling was correct. The motion court denied Dalton's request for an audio recording of an interview of James Wood, who was on the prosecution's witness list for Tompkins's trial. Wood, who at times was in custody with Tompkins, reported Tompkins made statements that were inconsistent with Tompkins' version of the crime that was presented at trial. We find this request similar to Dalton's request for Moran's statements and conclude the prosecution must turn over the audio recording of Wood's interview on remand. The motion court shall order the prosecution to produce the recording if it is in the possession of the prosecution team. The motion court denied Dalton's request for statements of Frank Elliott, who had been interviewed more than once, but was not on the prosecution's witness list for any of the co-defendants' trials. Even as modified, this request resembles Dalton's request for Roger Tavolazzi's statements. The request was properly denied. The motion court denied Dalton's request for statements of Cheryl Stebbins, who was on the prosecution's witness list for Baker's trial. Dalton has Stebbins' statements from one interview, but requested statements from another interview conducted by law enforcement. This request is similar to Dalton's request for statements by Moran and Wood, which the court denied. On remand, the motion court shall grant the second interview request if it is in the possession of the prosecution team. Dalton requested copies of 911 calls from locations associated with the crime. The motion court ruled that 911 calls made by witnesses or individuals on the prosecution's witness list for Dalton's trial are discoverable and must be provided if they are in the possession of the prosecution team. We modify this ruling to include individuals on the prosecution's witness list for Baker's or Tompkins's trials. Dalton claims that in approximately 1989, Tompkins was interviewed by the gang unit at Soledad State Prison regarding the Rainbow Occult. Dalton also asserts that CDCR staff performed at least one psychological evaluation of Tompkins and found him to be extremely violent. To the extent that the prosecution team, which does not include CDCR unless it is participating in the investigation of the charged crime, has these materials, Dalton is entitled to post-conviction discovery of them because 1. They include statements by a co-defendant, b. and Dalton would have been entitled to them had she requested them as part of pretrial discovery, and 2. The psychological evaluations of Tompkins would be potentially mitigating evidence at the penalty phase of Dalton's capital trial on remand. The motion court shall order the prosecution to produce these specific CDCR materials if they are in the possession of a prosecution team member. Dalton unsuccessfully sought post-conviction discovery of rental receipts for the apartment building in which victim May lived before she was murdered. Dalton claims sheriff investigators obtained the receipts as part of the investigation of this case. Dalton argues that if her attorneys know the identity of the people living in the building, they can better track down George, an unidentified fourth murder suspect. Dalton also claims the receipts would be relevant to impeach co-defendant Baker's statements that she and May met George on the day of the murder at an apartment in May's complex. Dalton argues she is entitled to the receipts under Steel Supra 32 Cal 4th 682, because if she had requested them at trial, the prosecution would have been required to disclose them under Section 1054.1, Subdivision C. We agree. On remand, the motion court shall allow Dalton to reasonably show that the rental receipts still exist and that the receipts are in the possession of the prosecution team. If Dalton shows adequately, the motion court shall order the prosecution to turn over the receipts to her. Dalton unsuccessfully sought post-conviction discovery of identifying information, names, addresses, and phone numbers of the tenants of the Live Oak Springs trailer park where May was killed. The motion court correctly denied the request. Requires specific discovery requests and not the proverbial fishing expedition for anything that might exist. Dalton sought post-conviction discovery of records of telephone calls made from 3 telephones near or at the Live Oak Springs trailer park. For one of the telephones, Dalton requested calls made for 5 days surrounding the murder of May. Dalton sought records of calls made for 3 months for the other 2 telephones. The motion court denied the request on relevancy grounds. Dalton argues the telephone records are relevant because prosecution witness Fedor testified she telephoned from her trailer, the site of the murder, at least once before and after the crime, and this was a disputed issue at trial. We agree that the phone records would arguably be relevant to the impeachment of Fedor, a primary prosecution witness. We also find that Dalton would be entitled to the records on this ground under Brady, Supra 373 U.S. 83. The duty to disclose. Exculpatory evidence under Brady includes impeachment evidence. At the post-conviction discovery stage, Dalton is not required to show the materiality under the meaning of Brady. On remand, the motion court shall allow Dalton to show that the requested phone records exist reasonably. If the showing is adequate, the motion court shall order the prosecution to turn the records over to Dalton if they have the prosecution team. Dalton sought post-conviction discovery of San Diego County Jail records for 16 individuals. The motion court denied the request except for a record concerning visits on a specific date for an inmate Fedor claimed she visited. At oral argument, Dalton narrowed her request to the jail records of 4 women who testified at trial about aggravating events that they claimed took place in jail. Dalton claimed the jail records were relevant to prove or disprove the women's testimony details and challenged their credibility. The requested jail records of the 4 women are arguably exculpatory evidence under Brady, Supra 373 U.S. 83. The duty to disclose exculpatory evidence under Brady includes impeachment evidence. At the post-conviction discovery stage, Dalton is not required to show the materiality under the meaning of Brady. We find that to the extent the prosecution has the requested jail records for the 4 women, the prosecution should turn over the records to Dalton. Dalton unsuccessfully sought post-conviction discovery of any materials regarding any other individuals whom law enforcement considered a suspect in the crimes charged other than Kerry Dalton, Mark Tompkins, and Cheryl Baker. This request is overbroad and was properly denied by the motion court with 2 exceptions. Section 1054.9 requires specific discovery requests and not the proverbial fishing expedition for anything that might exist. The 2 exceptions are Dalton's sub-requests for information regarding credit card information for gas stations in 3 communities near the trailer park on the days surrounding the murder, and information regarding guests registered at 2 nearby motels on the day of the murder and the following day. Co-defendant Baker said a 4th suspect named George used a credit card to pay for gas at a station in the area, and that she, Dalton, Tompkins, and George rented a motel room after leaving Fedor's trailer Information falling within these two exceptions, if it exists and is in the possession of the prosecution team, would be discoverable under Brady, supra. On remand, the motion court shall allow Dalton to show this specific information reasonably. Upon an adequate showing, the motion court shall order the prosecution to disclose the information if it is in the possession of the prosecution team. Dalton sought post-conviction discovery of the arrest records of Tompkins and Baker. The motion court correctly denied these requests. The motion court had already ruled that Dalton was entitled to all prior felony convictions and any prior misdemeanor convictions involving moral turpitude for Tompkins and Baker, among others. Dalton argues she needs the arrest records of her co-defendants for the penalty phase to present a mitigation theme of diminished relative culpability and to contest the prosecution's portrayal of her as the moving force behind the crime. We disagree. The jury had the trial evidence to consider in evaluating the perpetrators' respective roles in the murder. Further, as to Dalton's potential diminished culpability relative to her co-defendants, their criminal histories of felony convictions and misdemeanor convictions involving moral turpitude were adequate to serve this purpose and for impeachment purposes during trial. Calls to release the co-defendants' arrest records for penalty phase purposes are unpersuasive.